Hi. So today I am going to share with you about the remedy you have when the seller makes an agreement with the buyer and defaults or doesn't come for registration and sells the property, immovable property, to third party when the agreement is subsisting. That is to say, the seller sells the immovable property to third party for a higher price or better opportunities when the agreement with the buyer is subsisting. What is the remedy that the buyer has in those circumstances? Undoubtedly, buyer must file a suit for specific performance. Suit for specific performance is a suit which I would explain in other videos. It's a specific suit for performing the agreement. The agreement, if it cannot be compensated with money, it must be compensated with land, with the property itself, then it is called a specific performance suit. In a general terms, the meaning of specific performance suit is this. Now, the seller sold the property to the third party, and as a buyer, your money is also stuck up with the seller. For some reasons, I am not going into the reasons. There could be delay in paying the balance sale consideration, or there could be dispute in the property, etc., etc. But what is the remedy the buyer has at those circumstances? The buyer must file a specific performance suit, undoubtedly, and the pleading in the specific performance suit must be very categorical and directed towards cancellation of the already executed sale deed. Now the seller sold the property to the third party. Now your prayer should be to cancel the sale deed. First, the sale deed must be cancelled, and then the property must be directed to be registered in your name, in the name of the buyer. So if these two prayers are not there, and an alternate prayer to refund the sale consideration, if at all court comes to conclusion that there is a problem with the agreement and the seller made a correct decision, then there should be an alternate prayer of refunding the advance money with interest. If these three prayers are not there in the plaint, then the plaint gets rejected. It's an opportunity even to the third party and the seller, who become the defendants in the suit filed by the buyer, who is the plaintiff, to file a suit, to file a petition in the name of rejection of plaint. Because the plaint has to be pleaded by the buyer in such a way that the document that is executed by the seller to the third party, registered by the seller to the third party, is illegal, and he should ask for cancelling those documents. Without cancelling those documents, buyer cannot ask for the transfer of property from the seller to his name, or if seller defaults by the court, to his name, without cancellation of the already existing sale deeds in favor of third party. So this is very important. If this is not done, then the seller and the third party can file a rejection of plaint, and buyer must be very cautious in filing the plaint if this is the situation against the seller and the third party. Hope I am clear. Thank you. Thanks for watching. If you have any doubts, kindly comment.